September 22nd. This is the Legislative Redistricting Committee. Call this meeting to order. First item of business is approval of the minutes from November 1st and November 8th of 2021. Moved by Co-Chair Perucci. Any discussion? Seeing none, all in favor say aye.
Aye.
Any opposed? I'll rule that motion carries. We appreciate everyone reconvening. This is unusual and quite honestly a first in our process of redistricting. Some of the things that we're going to talk about today were not applicable when we last met, and we want to make sure that you understand that we are doing this in compliance with the court's orders and under protest, but we want to make sure that we maintain our constitutional duty to produce a map, and so we are going to proceed in that direction. Right now in the beginning, we do have a couple of, at least one new member, I believe. I'm going to start down there with Senator Ibsen, and let's introduce chairs quickly and tell people where you represent. We'll get your right mic on here.
Thank you, Mr. Chair. I'm Senator Ibsen. I represent Senate District 29, which is St. George in Washington County.
Doug Owens, representing District 33, Mill Creek, Olympus Cove areas here in Salt Lake County in the House of Representatives.
Good morning. Senator Luz Escamilla, Minority Leader in the Utah State Senate, representing Senate District 10, Northwest Quadrant of Salt Lake City, West Valley City, and Magna.
I'm Senator Lincoln Fillmore from South Jordan. It's District 17, and that includes South Jordan, West Jordan, and Harriman.
Representative Cal Roberts, represent House District 46, Draper, and a little sliver of Bluffdale.
Representative Stephanie Gracious, Eagle Mountain, Cedar Fort, Fairfield, Genola, and West Mountain, District 50.
Representative Walt Brooks, representing District 75, which is St. George, Pine Valley, Enterprise area.
Mike McKell, Senate District 25, from Provo to Santa Clara.
And I'm Senator Scott Sandel. I represent Senate District 1, which is all of Box Elder County and a portion of Cache and Tooele counties.
I'm Representative Candace Perucci, and I represent Harriman and Riverton, District 49.
Thank you. I'll also recognize that we have Senator Brammer, who will be presenting later on. I just asked him to sit up on the dais in case we were short on some seats. So just so you'll know, the rest of those up here are staff, and appreciate them. In the beginning, I want to remind the public and our committee members in particular that this process is different from our committee before, in that we cannot consider any partisan data into consideration of these maps. We cannot consider any incumbency or names associated with any of the congressional districts. I've asked staff, as public comment comes in on the written comment, I've asked staff to look through that and sort out any inappropriate partisan comments and only allow those will remain public, all of them, but only pass forward to the committee those that meet that requirement. We'll get into a lot of the detail on how the maps that were before us have been done. I won't do that right now. I will remind the public that as you consider what you may say to us today in public comment, that we cannot consider any partisanship. If that's part of your testimony, know that it has to be disallowed in our minds, and if you want to reconsider how you say something, the way you say something, that may be helpful as well, just to help us abide by what the court has determined we have to do. This meeting today has been posted. You have seen the agenda. Between now and Wednesday, the committee members will review what we've talked about. We will meet again on Wednesday. We will consider any action at that point that we want to take. Expectations for Wednesday would be to again have some public comment in the Wednesday meeting. Today we have a hard stop at 2:30 in the afternoon. Somewhere in the middle of that for staff and for everyone, we will intend to take at least a recess somewhere, just to be able to allow staff to get up and move around. Then after Wednesday, our expectations are that by the 6th of October, we will come back in special session and vote on a map. I'm going to now turn to my co-chair to see if there's anything that she would like to add.
Just appreciate the committee members being here again. I know everyone has busy schedules and busy lives, and this is important, though, that we're doing this and maintaining our constitutional authority of being able to direct the map drawing process and the map selection process. So I also want to thank our staff. They have been working round the clock. It has felt like we were in session the past couple weeks, and so I know that they have spent a lot of time and canceled trips and made an effort to be here. So just want to thank our staff and also thank the public for joining us on this early morning, and appreciate you coming to make sure your voice is heard. And there'll be a time later today for public comment as well. So thank you.
Thanks. Again, I offer my thanks to staff. I don't think there's been a day in the last 2.5 weeks that we haven't met with them or called upon them or asked them to do things to try to meet this tight, compressed deadline that we've been asked to do. I'm going to now turn the time over to John Cannon, who's going to talk about Redistricting 101. We'll follow that up with Alan Houston. I almost said Houston, and I know better than that. Houston. Talk about the litigation. Tom Vaughn will then go through the Prop 4 standards, and Mike Curtis will then do the partisan prohibition. So we're going to start with that. Mr. Cannon, let's get a mic on. There you go.
Thank you, Senator Sandel. Thank you. Chairs, committee members, good morning, everyone. John Cannon, Director of Legislative Research and General Counsel, and staff to the committee. I appreciate having a moment this morning to talk just very briefly about redistricting. Just a couple of moments about what redistricting is, why we redistrict. We'll get a little later in these presentations to why we're redistricting now as opposed to right after the census. But I just want to take just a moment to share just a couple of things about why and what redistricting is, and then just a couple of notes about data, because it's a little bit unusual to be doing a mid-decade redistricting, and so some notes about the data that we're using for this particular go-around of redistricting. For those of you who were involved in this before, you may remember there was a fairly significant presentation that was given at the beginning of this, and I know Senator Ipson reminded me that he's been through this a few times. He was involved in this in 2011, as well as 2021. In 2021, there was a 51 slide deck presentation. I'm going to try to do it in 2 slides today, so you're welcome for that. So we'll start with just a couple of quick slides about what redistricting is. In short, redistricting is the process of redrawing electoral district boundaries that occurs after each of the 10-year census. When that census is taken in years that end in 0, then data is delivered to each of the states, and they redraw their district boundaries. In this state, in Utah, we do that for these types of districts. We do it for our congressional districts in the United States House of Representatives. We, of course, have 4 House districts. We do that for legislative districts, for state Senate and state House, and we do that for state school board districts. That's the very simple explanation of what redistricting is to redraw those boundary lines for those electoral districts, for those particular types of districts in the state. So why do we do that? The bottom line kind of fundamental principle behind redistricting is the idea of equal representation. Over time, because of population growth, because of population shifts, things get out of whack. So if you think through the decade of 2010 to 2020, let's say in 2010 a House district had, all the House districts started with roughly 40,000 people. By the time you got to 2020, you could have House districts in Northwest Utah County that were 2 to 3 times that were into the 80 to 100,000 people, or in Southwest Salt Lake County, while others were still at that 40,000 or had even shrunk. And so you had representatives in the House, in the State House of Representatives, where you had 40,000 people being represented by one person, and you had 100,000 people being represented by one person. That is not equal representation. That's not one person, one vote. And that's why you come back every decade and you redistrict to kind of level set and ensure that you have that equal representation for the people. So that unequal population growth and shifts over time, that's what creates that inequity, and that's what redistricting is intended to resolve. So that's the fundamental principle behind redistricting and why the legislature redistricts. Of course, there's also a constitutional provision, and I just lost one here. Let me go back. That final bullet point then in our state constitution, Article 9, Section 1, which says that the legislature, following the receipt of the results of the census, then the legislature shall divide the state into congressional, legislative, and other districts accordingly. So that's my attempt to boil 51 slides down into 2, to just say why we're redistricting and what redistricting is. And again, we'll get into Tom will get into the standards of redistricting this time, and Alan will talk about litigation and why we're redistricting now. I do just want to then get into just a couple of notes about the data, just to be clear as we get into this process and you start looking at maps. The districts this go around will still be drawn using the 2020 U.S. Census data, and that has been stipulated to by all the parties that are involved in this litigation. So the data, we know that the data now is 5 years old. The data, the population data was intended to be a snapshot of the population of the country as of April 1st, 2020. We know there's been a lot of growth since then, but it's the best data we have. It's the data set that everyone can agree to and everyone has agreed to. So that's the data set that we are using. The other note here is that in addition to population data with the census, you also have a set of geographic data. So the lines in the state, the census blocks, which is the lowest level where we have population that you use as the building blocks for these districts that you use to redistrict. And those that geographic data also includes municipal lines. That is a snapshot of those boundaries in that data as of January 1st, 2020. That is the data that we are also using for this redistricting exercise that we are going through now. And again, we know that in reality, things have changed. Annexations have happened, boundaries have moved, but we are still using, and all parties have agreed to use, the boundaries as they were reflected January 1st, 2020, and as they're reflected in that census data. A couple other notes as we talk about data and as we get into Prop 4, and Tom will get more into these standards. But once you get past population, which again is the fundamental standard, the top priority in redistricting to equalize population for that one person, one vote principle. The next requirement, the next standard in Prop 4 is that maps be drawn to minimize, to the extent practicable, the division of municipalities and counties. So a couple of notes there. We have 4 cities in the state that extend across county boundaries. That would be Bluffdale and Draper, which go across the Salt Lake and Utah County border. So both those cities have pieces in those 2 counties. And then you have Park City across Summit and Wasatch County, and Santaquin, which goes from Utah County across into Juab County. So as you think about where you draw lines, if you are keeping cities whole, you're dividing counties, or vice versa. If you're keeping counties whole, you're dividing cities when you look at these particular parts of the state. So just a couple of notes there about data. So you have to make decisions with regard to how you divide things. The other is, again, when you talk about how you divide these, when you divide municipalities and counties, one of the questions that I've been asked many, many times is, Why don't you just make Salt Lake County a congressional district? That would be very simple. Just make Salt Lake County one district. Population of Utah, as of the 2020 census, was 3 million, as you see there, 271,616. To get the ideal district size, very simple, you divide that by 4. So that gives you the population of an ideal district, 817,904 people. Happens to be divisible exactly by 4 in this case. So that is your ideal district size. The population of Salt Lake County as of 2020 was 1,185,238. So Salt Lake County then has to be divided because you have roughly an extra, it's dangerous to do math in public, but an extra 367,000 people in Salt Lake County. So you have to divide Salt Lake County. So just a few notes again about the data as you consider maps, as you start looking at them, some things that you have to consider and the data set that you are using. So, Chairs, that concludes my portion of the presentation. I'll pass it on to...
Thank you, Mr. Cannon. Let's move to Alan Houston.
Thank you, Chairs. Alan Houston, Associate General Counsel with the Office of Legislative Research and General Counsel. I'm going to be talking about, as John said, the litigation that's been happening and why we are here today to redistrict in the middle of a decade. Okay, so this the litigation really starts back in 2018. In 2018, the voters of the state passed Proposition 4, which made changes to state law regarding how redistricting happens, the process by which it happens, and the standards that are followed when drawing these lines. So that passed in 2018. In 2020, the legislature, during its general session, passed SB 200, redistricting amendments, which made changes to the provisions that were enacted through Proposition 4. It made changes to how the redistricting process happens and, again, those standards by which the lines are drawn. After the legislature passed SB 200 in 2020, the annual or the decennial redistricting happened in 2021 after that census, and the legislature, following the processes and standards in SB 200, passed HB 2004, which enacted the congressional map for that round of redistricting. After that map was passed in 2021, a lawsuit was filed by the plaintiffs listed here, challenging the congressional map and the adoption of SB 200 and the changes that made to the redistricting process and standards from Proposition 4. The legislature, in response to that lawsuit, filed a motion seeking to dismiss the lawsuit. That motion was granted in part by the district court. The district court dismissed the plaintiff's claim at that time, challenging SB 200 and the changes that were made to Proposition 4 by SB 200. That decision was appealed to the Utah Supreme Court, and in July of last year, the Utah Supreme Court reversed the district court's opinion, said that the plaintiff's claim challenging SB 200 and the changes it made to Prop 4 was a viable claim, and sent that claim back to the district court for determination of the merits of that claim. Then in August 2025, last month, the district court resolved that claim, ruling in the plaintiff's favor, saying that SB 200 and the map, the congressional map that was enacted pursuant to those procedures and standards, was invalid. So the court enjoined that map, which means there is currently no congressional map in place to conduct the upcoming election next year. The court also enjoined SB 200 and said that Proposition 4 is now the law of the land. So we are here again because we do not have a congressional map currently, and we are required to follow the standards and process of Proposition 4 to get a new map. So what does that mean now? That means we are here trying to do that. As the chairs have said, we're here in compliance with the court's order and trying to follow what the court has ordered the legislature to do. We are here on Monday, September 22nd, having this first committee meeting. To start that process, there will be a second committee meeting this coming Wednesday. And by this coming Thursday, the court has given the legislature a deadline to publicly post its proposed map or maps so that they can be available for a public comment period. The public comment period will start on the 26th then and run through October 5th. There's roughly 10 days or so of public comment. And after the public comment period closes, the legislature will come into a special session and pass whatever map it chooses as the map. That's the deadline the court has given for both parties, the plaintiffs and the legislature, to submit their proposed maps to the court. So the parties will file those maps on October 6th. And then on October 17th, the parties have the opportunity to submit briefs and expert reports, both in support of their map and in response to the other side's maps if they choose. Then following submission of those expert materials, there will be an evidentiary hearing on October 23rd and 24th. You'll see it's noted here, if that's necessary, if the parties agree on a map, I guess we won't have to go through this exercise. But that evidentiary hearing has been set aside, those dates have been set aside by the court so that the court can hear testimony and evidence regarding each side's proposed maps. Following the evidentiary hearing, the parties will submit proposed findings, fact, and conclusions of law to the court on October 28th. And then November 10th is the deadline that the lieutenant governor has given and said that's the date by which she needs a map in place to begin preparing for the election, the 2026 election. So we anticipate the court will make a decision on the proposed maps on or before November 10th. That's the end of my presentation, Chair.
Thank you very much. As we go along, committee members, if there are questions to staff, please just let me know. I'm going to now move to Tom Vaughn, Proposition 4 Standards.
Thank you, Mr. Chair. Thomas Vaughn with the Office of Legislative Research and General Counsel, one of the attorneys assigned as legal counsel to this committee. I'm going to just briefly talk about the Proposition 4 Standards. Proposition 4, which is now the law in Utah, requires that this committee abide by certain standards and requirements in passing a new congressional map. The statute specifically says that we're required to abide by the following redistricting standards to the greatest extent practicable and in the following order of priority. The first one, the first standard says that we have to adhere to the Constitution of the United States and federal laws, and that includes the Voting Rights Act, and then including to the extent required, achieving equal population among districts using the most recent national decennial enumeration made by the authority of the United States. So what this means, the having an equal population or a population deviation that is as equal as possible, when it relates to congressional maps, there is Supreme Court case law on this issue, and it basically requires that the maps must be nearly equal in population as practicable, with a deviation not greater than plus or minus 0.1%, and you drive that down as close to zero as you can get. In Utah, we have taken that very seriously and got it as close to zero as we possibly could. The maps the legislature passed, the last time the legislature passed congressional maps, had a deviation of zero. All 4 congressional districts had the exact same population. And that's important, and you're able to more easily defend that you've complied with that if you don't have any deviation at all. Then we, after that, again, remember this is in an order of priority. So as you get down this list and consider these factors, you don't want to consider them at the expense of the ones above. The next standard is minimizing the division of municipalities and counties. But it says that we are supposed to give priority, first priority, to municipalities and second to counties. So as Mr. Cannon said, we've got a situation where we've got 4 cities that straddle counties. And because of that, because we're giving municipality division priority above counties, we're going to split the counties before we split the cities to the extent practicable. And so that's a goal you'll be doing. The next goal is compactness. This is a standard that the legislature has traditionally followed. We don't want something that looks really crazy and goes out and has one long arm and grabs something. We just want something that's reasonably compact to the extent that it can be complying with the preceding principles. Next standard is contiguity and ease of transportation. The legislature has always done districts that are contiguous. You don't have to leave the district to at least get to the other part of the district in a straight line. Now, sometimes transportation might require you to briefly do that, but we do take that into consideration, the ease of transportation. Then we look at preserving traditional neighborhoods and local communities of interest. Now, this is an interesting factor because it is in the eye of the beholder. There are so many things that can qualify as a community of interest or a local community. Some of those are already defined politically in Utah as political boundaries, right? Municipal boundaries, county boundaries, those are communities of interest, arguably. But things as small as school districts could be a community of interest. There are so many things, and so that's something that is in the eye of the beholder. Following that is to follow natural and geographic features and boundaries and barriers. So some examples of that in Utah would be the Colorado River is kind of a natural barrier that there's not a lot of places you cross, and so that's something to take into account. But again, not as important as population deviation and those things before it. Mountain ranges, other types of boundaries are also important. Even roadways can fall within that. Okay. So those are the standards, and again, in order to the greatest extent practicable and in the order of priority shown. I'm waiting for the slide to advance. There it goes. Okay. There's also a partisan prohibition in Prop 4. And it says that the legislature and the commission, referring to the Redistricting Commission, here it's just important to the legislature today, may not divide districts in a manner that purposefully or unduly favors or disfavors any incumbent, elected official, candidate or prospective candidate for elective office, or any political party. Chair Sandals already pointed out that we are taking, I think, above and beyond what they're even required to do to avoid even seeing that information, and taking this very seriously to draw a map that doesn't do this. So you'll see you can't do that purposefully. You also can't do that unduly. So not only is your intent matter, but the results matter. And in just a couple minutes, Michael Curtis will talk a little bit more about how we determine that that standard has been complied with. We'll just say that we don't look at any of that until after the map's drawn in accordance with the Prop 4 standards. After that, it's evaluated to see if we accidentally drew it in a way that favors or disfavors a political party or so forth. But again, Michael will go into more detail on how that's done. There we go. Okay. Just keep in mind, there's been some discussion or questions about legislative preferences. What I mean by that are things like, would we prefer to have an urban-rural mix? Would we prefer to, do some certain things that are important to us as we're looking at this? So the things that are that we need to keep in touch here when we're considering these legislative preferences are a few words of caution. They are not redistricting criteria. Okay, the Prop 4 standards control. They're not criteria. They're something less than that. Any legislative preference cannot violate Prop 4. Any of those provisions we just talked about. And they may only be used to help choose a map that is, quoting the statutory language, to the greatest extent practicable, compliant with Prop 4. In the court's orders in this case, as Mr. Houston referred to, the court recognized that there are competing interests in application of the Prop 4 standards, and the court recognized that the legislature is required to apply them to the greatest extent practicable. The court goes on to say, and I'm quoting, the statute itself provides some discretion in balancing competing interests and in making policy considerations, end quote. And so that's when we're balancing those competing interests, legislative preferences are something that we can consider taking into account the prohibitions that I've listed under legislative preferences on this slide. I'll now turn the time back to the chair.
Thank you, Mr. Holland. I don't see any questions at this point. So we're going to turn the time over to Michael Curtis to talk about the partisan prohibition.
Hey, Senators, Representatives, Mike Curtis with the Office of Legislative Research and General Counsel. I'm also one of the attorneys for the committee. Pardon, I went backwards. As Tom mentioned, the statute now includes this prohibition on dividing districts in a manner that purposefully or unduly favors or disfavors an incumbent candidate or party. But how do we know whether a redistricting plan violates that? Prop 4 requires the legislature and the commission to use judicial standards in the best available data and scientific and statistical methods, including measures of partisan symmetry, to assess whether a redistricting plan is compliant. And then finally, it tells us that partisan political data and information may not be considered except to run that analysis that's described in subsection 4, which is measures of partisan symmetry. So as Tom mentioned, partisan information in any form, in any kind of metric or statistic, can't be considered in compiling a plan, a map. But after the map is complete, an analysis has to be run to ensure that we haven't purposefully or unduly favored or disfavored. So I'm going to talk just a little bit about what partisan symmetry is. So we have a quote from a concurring opinion in a Supreme Court case from back in 2006, one of the cases where the federal Supreme Court was talking about partisan gerrymandering or considering whether there was a justiciable claim for partisan gerrymandering. And they described the symmetry standard as requiring that the electoral system treats similarly situated parties equally, so that each receives the same fraction of legislative seats for a particular vote percentage as the other party would receive if it had received the same percentage. So just to break that down a little bit, let's say Party A receives an average of 55% of the vote total across the state's district elections, and because of the way the map is drawn, Party A wins 70% of the total seats. The question under partisan symmetry is what happens with Party B if Party B got 55% of the vote. So it would be fair if in an election where Party B received 55%, Party B would also have won 70%. So under symmetry, the question isn't whether the seat share is symmetric or proportional, to the vote share. It's whether if Party A gets 55% and gets a certain outcome, if we flip the vote and Party B gets that same vote, do they also get that same outcome? Okay, that's the symmetry standard that's in the language of Prop 4. So in that order that Alan talked about previously, Judge Gibson acknowledged here that because of the general non-specific nature of the language referring to this measures of partisan symmetry, statistical and scientific and statistical methods, the legislature retains discretion in determining which are the best to use in evaluating redistricting plans. So, and noted that this provision doesn't impair the partisan symmetry measure. Requiring it does not impair the legislature's authority under Article 9 and does not displace the legislature's legislative redistricting authority. And so I think that is our pivot point into Senator Brammer.
Thank you, Michael. I've got a question, and I agreed to take those questions. Is that Representative Owens? Oh, Senator Escamilla.
Good morning, Mr. Chair. Thank you. That's me. Question to the Attorney Curtis. Can we go back to your subsection 4, so one more back, before the partisan symmetry definition? Just making sure we're all clear. It says best available data and scientific and statistical methods, including partisan symmetry, meaning the Prop 4 was very clear that there is more than just partisan symmetry. Am I correct or not?
That's correct. Yep.
Okay. And then we go back now into your definition of partisan symmetry. This 55% or 50%, 55% average. That's, just to be clear, a hypothetical, because that has never happened, at least in 50 years or 100 here in Utah. Am I correct or not?
Yeah, no, these numbers are just to demonstrate the concept that whatever seat share one party gets based on that vote share, that same ratio should be applied if the other party got that same vote share.
Okay. In a hypothetical.
Yes, and Senator,
correct.
We do use the hypothetical so as not to discuss any partisanship at this point in time. The actual numbers that are applied, we don't see as a legislature. They're applied outside of our purview to understand partisan this partisan symmetry.
And Mr. Chair, if I can make one
yes,
more
go
comment
ahead.
Based on your reference right now, that hypothetical that you're talking about, which in this case is an average of 55% for party A, correct? That's what we're using for this definition.
Yes.
Just to be clear, there is also within hypotheticals implausible versus possible. And I'm just putting out there saying we're not mentioning any political affiliation or parties, but that is as you are working in statistical, scenarios, that is something that, to my personal view, should be also discussed in all the metrics that we can use. Because again, Prop 4 was very clear that it was giving opportunities for statistically the best ones, right? And the Judge Gibson stated that again in the last, I don't know, the last piece, page 29 of her opinion, that we still retain that discretion in determining what judicial standards are applicable, and they retain discretion on determining the best available data and scientific and statistical methods, including partisan symmetry. Just to be clear that there's more than just one way
Yes.
and avenue. Okay.
Yes, that's a fair statement.
Okay.
Yeah.
Thank you, Mr. Chair.
Okay, thank you. Committee members, we're now going to pivot. That was a good lead in, actually. The legislature is going to have to determine which standard we use. And we have Senator Brammer, who has a bill file open. And we're going to discuss that bill file. Committee members, I will let you know that we're going to hold any action on this bill file today. We will not take any action, but we wanted to make you aware of it, as has been stated. The judge indicated that the legislature needed to define this, and this is an attempt to define this particular issue in this bill file. There you go. I think your mic's on.
Thank you, committee. So, let's talk a little bit about some of the things that we're balancing and trying to choose a test and why we would do this. So let's first go to the key language of Prop 4. We have Section 3, and this is codified in 20A 19103. And I want to highlight the two areas that are on your screen in red, where it talks about whether it unduly favors or disfavors any incumbent elected official, as well as that it includes specifically measures of partisan symmetry. Now that's important because the writers of Prop 4 did not include the phrase proportionality. Instead, they included partisan symmetry. And that's a key distinction. We go off the language as passed, as opposed to something that may be a hope that was not expressed in the language of Prop 4. And so we are looking specifically for the measures of partisan symmetry in adopting a standard. That is what Prop 4 asked us to do. So let's go to a few of the items in Judge Gibson's order. And this is from page 29 through 30, and this was highlighted by Michael, but it is an important part of the ruling because it does show that the court, and here the court says further, given the general non-specific nature of the language, specifically referring to Prop 4 language. That's commonly a critique of the courts, and we see that all the time in legislation when the courts say, hey, this statute is not as specific as we would want. And when we see that, in fact, we have a report every year to the judiciary that says, hey, the court has now signaled that there is something that is not clear in the statute, and they are inviting the legislature to come fix it. We see that all the time, and we respond to that, and that's appropriate for us to do. And then the court specifically says the legislature retains discretion in determining. Now, note that this is specific to the legislature and the legislature's discretion, and not necessarily a party submitting a map. This is specific to the legislature on determining which judicial standards are applicable. And so here the court is noting that this legislature has the authority within the bounds of Prop 4 to determine which judicial standards should be applicable, and specifically as to the best available data and scientific and statistical methods. And so we're trying to do that to the best that we can. Now, we can have a disagreement, and in every case, there's a series of experts, and particularly in redistricting cases, there are a group of experts on either side of the case that say, my method is the method, and then the other one says, my method is the method. But what we're trying to do is provide some clarity for the courts, because as you'll see, the courts become, it's a difficult issue for courts to deal with. So let's talk a little bit. So there's that part where the court has already tipped their hand saying Prop 4 is a little too general and non-specific.
Let me pause for a minute. Excuse me, sir, with the camera. We don't allow the cameras inside, so we'll need to have you off to the side. Thank you. Okay. It was on my good side, so I was pretty happy with it. I don't have a good side. It's okay. We are following what we see in the judge's order as something that would be helpful to the court here. And we're trying to do that in order to support exactly what Prop 4 says, which is partisan symmetry. How do you deal with that? And that partisan symmetry language has been discussed in an ephemeral way in cases throughout the jurisprudence. But one thing that is unique to Prop 4 is it is the first time that language was ever used in any statutory or constitutional issue. And in others, they've used things like proportionality or other standards. In Prop 4, they were quite specific to partisan symmetry in their language. And so we need to stick as close as we can to Prop 4, and that's what we're trying to do. Additionally, this is in keeping with the League of Women Voters decision from the Utah Supreme Court, where it says the legislature could amend a government reform initiative in a way that does not infringe the people's reform right. For example, if the amendment furthered or facilitated the reform, or at least did not impair it. Now,
in this case, where we are trying to facilitate, we're trying to facilitate the reform. We're not trying to impair it here. The court has said this would be helpful. It's general, non-specific language. This would be a helpful thing. We're trying to facilitate it. And that's an important distinction because the court has said when you're trying to hurt the standard, then it's a strict scrutiny analysis, which is much harder to overcome when the government acts. However, when you're trying to help it, particularly when you've been invited by the district court to help it, that is under a rational basis test analysis. And that's an important distinction under the law. And so now let's go to what we're talking about, which is the partisan bias test. So again, this is the first state to put in code the term partisan symmetry as a districting criterion. It is used to measure partisan symmetry by measuring lines of a district map and determining whether each party has a symmetrical opportunity to win a seat. And then votes are equalized to evaluate if lines of a district map are fair. The hypothetical election used is separate from the actual outcome of the election, meaning we know that the redistricting process, it sets a map, but those maps and the outcomes of those maps fluctuate, every single election cycle. That's why in almost every midterm election cycle, there's a flip of the House of Representatives nationally. Even though the map, regardless of whether the maps change, it's because voter preferences change, and you want to have a chance where maps can flip, and every single district needs a chance to be able to flip. Okay, now the hypothetical election used is separate from the actual outcome. The results of the test demonstrate if the map is skewed to one party or another. So here's the key principle: the outcome of an election should be determined by the voters and not the map. Okay? And there's two ways that it's determined by the map. You've got packing and you've got cracking. Now, we hear a lot about around Prop 4, this idea of, well, this map is cracked. But we also need to evaluate and have a standard to determine whether or not the map is packed. And the reason why a packed map is so dangerous in a system is because when you have a packed map, it puts all the voters into one. And in our case, if you have 4 districts, you have one that is a guaranteed victory for one party, but then you have 3 that have absolutely no possibility of victory for the minority party. You've rendered 3 seats unwinnable. Okay, so let's talk about the key advantages on this. Chair, could I get an instruction?
Yeah. Let me stop for right now. Okay, we have certain rules around presentation and here at the Capitol. One of those is we don't allow for outbursts. We don't allow for applause. And we were just barely on the edge of that with the last reaction from the audience. And we're not going to allow that in the presentation. No matter how you feel, we're just not going to allow it. We have those rules during the session, and we have them during our committee hearings. So thank you, Senator.
Thank you. Okay, so the Supreme Court has long lamented what they call the snakes, sacred Mayan birds, Rorschach inkblot tests, and uncouth 28-sided figures that creative cartographers have made into legislative districts. Additionally, the Supreme Court and other courts have grappled with various statistical models, but have declined to adopt any specific model due to differences in circumstances. And so we're trying to adopt a model that is specific to the circumstance of Utah, and that's important in this instance. This model protects against both cracking and packing. This does not run one way. Prop 4 was not written to run one way. It is meant to protect against both packing and cracking. Now, this map favors electoral responsiveness, and electoral responsiveness also results in a more moderate group of representatives. And I'll talk a little bit about why that is. But one of the good things about having a test is it creates a pass-fail as to whether you've achieved partisan symmetry. And that's important because, number one, the parties can know as they submit their maps, rather than waiting for litigation to determine if they met the test. Now, regardless of who you are, you spend a lot of time on the redistricting committee. This committee, as well as the independent redistricting committee, spend a whole lot of time evaluating whether their maps meet the criteria of Prop 4. But if you're going to have a series of complicated statistical methodologies of which the court is unclear as to which they should approve and which they shouldn't, and you're going to have battling experts, what you're doing is you're guaranteeing every single map in every single instance, if you don't have a standard, has to go to court, and then you're waiting for the courts to decide on a map. As opposed to, can you in good faith adopt and follow the standards of Prop 4, adopt a map, and know that you're on safe ground in doing so? And we want to create a process by which that can happen. So I want to give an example. So for example, here's a scenario where you have 4 seats. If you were to create a scenario where a minority party has a 95% chance of winning, what that does to the rest of the map is it creates no chance of winning in the other 3 seats. And so what that means is you've created a system where in those 3 seats, you have representatives who are more likely to run to the extremes of their party. And in the 1 seat, you have representatives that are more likely to run to the extreme of their party because you've packed the map. They do not have to listen to the constituencies within their borders because you've created something where the map only favors one party. Now, let's not deceive ourselves. In Utah, we have a supermajority Republican state, meaning in terms of registered Republicans, 50.5% of the electorate is registered Republican. 13.9% of the electorate is registered Democrat. And when you compare the every 4 years of statewide elections, especially particularly on presidential years, which is what we're using. So we're talking the president, the governor, auditor, attorney general, and treasurer. What that typically results in is about I think it's somewhere around a 60 to 70% ends up being Republican vote.
Senator Brammer, I'm going to stop you because I think it's important to stay in the hypothetical because we're erring on the caution of any of the numbers in the actual.
Yeah. And so what this means is it does account for the reality of how things work, but it does so by giving the redistricting, whether it's independent or not, a chance to understand whether they comply or not. And that uses a regression analysis, which is a hypothetical in the sense that it uses statistical modeling to show likely outcomes and the variance of likely outcomes, because we know that it varies every single election. It dips up and down several points. So one of the standards that is commonly attempted to be used is the efficiency gap. Now, I don't think that is what the amendment by Senator Escamilla discusses. I think that one is the median means test. And we can talk a little bit about that, but the median means test has typically been discussed, but has not been adopted as the primary methodology. Typically, it comes down to, does a court rely on the partisan bias or the efficiency gap? That's what most of the court cases over the years have looked at. And so I've addressed efficiency gap. Median means test has been a tertiary kind of side conversation that hasn't really been used. That I've seen, it's discussed but not used. And so why not the efficiency gap? So the general concept of an efficiency gap is the wasted votes by each party should be approximately equal among all districts. And that's the idea. However, it is not reliable statistically in states with fewer than 6 districts. And so we can't use that as our model here. And in fact, if you go to the North Carolina case, which involved the League of Women Voters, the same group that's suing the state in the state of Utah, their expert, in the decision, it notes that the League of Women Voters expert concedes that the sensitivity of the efficiency gap in jurisdictions with only a few districts, in the case of congressional districts, states with 6 or fewer districts, renders it difficult, if not impossible, to apply. in states entitled to a small number of representatives, a partisan gerrymandering plaintiff simply will have to rely on different types of evidence. And so that's why we can't use efficiency gap. And so we've removed that as, that was kind of ruled out as statistically not viable. And so that's, and so going back to, why this works, it really came down to, we wanted to provide some certainty so that courts are not left with a dizzying expert battle, but instead parties have the ability to move forward, or redistricting committees have the ability to move forward with some certainty as to whether or not their maps meet the criteria for partisan symmetry or not. And, I don't think the courts want to be involved in every single redistricting process for all time. I don't think that's what the objective of Prop 4 was. But the objective of Prop 4 was, can you follow this criteria? And what is it? And then what we're defining is what the court really invited us to do, which is, what statistical models should the legislature use its discretion to adopt for purposes of determining partisan symmetry? And with that, I'm open to any questions.
Thank you, Senator. I will remind the committee, one, that we are not going to take any action on this particular item today. We wanted an explanation. We wanted people to be able to understand. And in quick terms, I will add that the hypothetical examples that you have seen or been given are that. They're hypothetical. But that the maps that are being considered, all maps that are being considered, will use actual data to make sure if they pass or fail. And that's important to understand. They're not given a grade of 1 or 1.1 or 1. It's just, do they pass the test or do they fail the test? And we don't see any of that with actual data as a committee. I've got a question. Is that Representative Owens? Is Escamilla again? Senator Escamilla.
Thank you. To the conversation and the presentation of the good senator, you mentioned that courts have recognized that there are many potential measures of partisan symmetry. So in the legislation that we're not taking action today, but you've presented, it's only about partisan symmetry. That's the only measure that you're proposing to have a test, which is a partisan bias test, correct?
Well, it's about it is about partisan symmetry, and it's addressing that specifically, but it also takes into effect the language in Prop 4 of whether it unduly favors or disfavors particularly political parties. And so that's shown through whether it meets partisan symmetry or not.
Okay. A follow-up question, Mr.
Yes, go
Chair.
ahead.
Thank you. So because you're correct in saying we do have case law, tons of case law on these pieces, I 100% agree with you that efficiency gap does not apply with, actually, my understanding after doing research, 8 districts. Anything below that, it's skewed and it's not going to help us. So I think we agree on that one. Yay. So maybe we can agree on the next one. There are other ones. So the other one is a mean median difference. And as you explained, my amendment, it's public and it's a little bit different because this is a special session type of committee. So it through advice of staff, you will see the amendment public with all the changes. So why for me it's important is, you mentioned you didn't think there was enough information. I kind of want to maybe challenge and talk to you more about how the median, the measure of symmetry regarding the mean median difference is applicable, and we can do that. But my question to you in terms of the evaluation intent, because I think what I'm hearing from you say is that you want to make sure that there is no gerrymandering. I mean, I think we collectively agree, and that's what the courts have said we need to do. So if we, don't you agree that it will be better if we have an evaluation intent and run simulations and this testing, whatever the test is, and whether it's, partisan bias or mean median difference, or in my case, I'm also including ensemble analysis, that we actually have an evaluation intent that involves, in order to make sure that we're purposefully component piece of the law, that we are not only, pushing some, the analysis effect of gerrymandering rather than the evaluation intent of that analysis.
So I think we both have the same goal. I'm not sure that I fully understand the question. Can you?
Yeah, and maybe, Mr. Chair, and thank you.
Yeah, make sure we come through the chair.
Mr. Chair, if that's
Go
okay.
ahead.
In terms of, I guess I will, maybe for me, the broader we get the different testing in place, because partisan bias to me, it really, I have issues with that, but I recognize it's one of a statistical, by the experts that I don't know any of us are here, right? And you mentioned there's so many cases all over the country with regards to this issue, that the more we have, and that's why adding the different ones that I put in my, motion, is that we do have enough to really value the intent. Because Utah, even in the hypothetical, as the chair was talking about, when we are going to run those tests, and you mentioned we have run tests on the maps, we've only run one test on the map, and that's partisan bias. And the court has been very clear in Prop 4 and the judge herself saying you should use all, as many as we choose to. It doesn't say we only have to use one. And so it concerns me when we're saying, we're running the test and we're getting a pass or fail grade, but we're only doing on partisan bias. And you're now trying to codify partisan bias as the only test to use. And that to me is a gigantic red flag, Mr. Chair, why I think we should have more tests and have them all then in a blind way, right? Through hypothetical, because partisan bias, you have to run through a hypothetical 50-50. I mean, that's the only way you run partisan bias. And whether we are not going to discuss whether that's real or not for Utah, it is a 50-50 hypothetical. So, and that way we're defeating the entire purpose of intent. And that's where my concern is by having the one only partisan bias, which is what the bill does.
Let me clarify. You are not running the test based on a hypothetical. You're only explaining the test based on a hypothetical. You're running the test with actual data from 3 past elections on 5 statewide votes. We don't see that as a committee. We don't want to see that as a committee because that breaches that divide that we're trying to stay on the one side of. But the actual test is run on actual data, not on. I want to make sure that's clear in the record in the statement that the actual test is run with data.
Mr. Chair.
Let me go first of all to Senator Brammer, and then we'll come back, Senator.
So if I could respond, I don't think that you're right. It's actual data, but where it is to some degree a hypothetical test is the idea that you're running it based on what are the possible outcomes.
Yep.
And because you're running it, it's a regression analysis or what's called a quintile analysis, and so it's simple calculus. I'm just kidding. It's what it is it's meant to show probability, just like you would on a bell curve. There's a probability and where it lies on the bell curve of potential outcomes that could happen, and so it runs that in a way that to say, given all of the potential outcomes moving forward, even with it is using real data to create the statistical model for that. It does have some level of hypothetical test because it's looking forward and saying, would this be fair statistically moving forward? Now that's an accepted scientific principle to do it. And I know that some people have tried to capture the idea that, just because you're looking at probabilities, that come out of that, when you do probabilities, you're doing a hypothetical test. And so the language in the bill actually does say hypothetical, but it uses our past data to make predictions of fairness in the future. And what this, part of the problem that we're trying to solve for is, can we get to a system that does not leave the courts in picking winners and losers, but instead gets the courts into the process of, did they comply or not? And you may disagree with the methods and with this being the best method or not, but we are tasked with choosing the best available method. Now, the parties could still use other analyses in their own data analysis, but for purposes of compliance, that is within the discretion of the legislature to choose whether it meets compliance or not for purposes of does it unduly favor or disfavor a party.
Thank you for that explanation. Senator Escamilla.
Thank you, Mr. Chair, for the time. So, and thank you for that explanation, because you are correct. The test will require a hypothetical swing in order to get there. And I think you're even talking about regression in some of the way you were explaining. And regression is not in your bill, correct?
Well, it is. The term regression is not, but when it says quintile in it, so, and I'll tell you the exact line, it's on line 27, through quintile analysis. That's usually, what it is it's part of a regression analysis. So it's a quintile analysis is a subset of regression analysis.
Okay. So, Mr. Chair, just to end, and thank you for the time. I think the quintile analysis, and I'm kind of like learning this as we go here as well, and studying this in the last 48 hours, is the quintile analysis does require simulations, and correct? And which in regression it doesn't. It just goes. But I mean, I would just end by saying my concern is that we're using only one, and that we're picking the one that I think favors the majority in the state of Utah in this hypothetical world, because you will have to use that hypothetical numbers and then run it in that simulation. And the other part I will say, I hope everyone gets to read that my amendment that I know we're not voting today on. There's no motions today, but the other part is that I also think it's important that we add U.S. Senate as a statewide race that is not included in that. So, and I was curious why.
I can explain,
Senator
I can explain why U.S. Senate was not chosen. What it does is it muddies the waters because the U.S. Senate is every 6 years. Rather than having a common data set of at the highest turnout point for voters every 4 years, there is a U.S. Senate data set that is on off years. And it muddies how the data is used. And so that hasn't been used for that purpose. We're also not using congressional races in this either, but we're trying to get statewide data for purposes of determining what the, I believe the partisan index would be.
Okay. Thank you. Thank you, Mr.
Representative Grecius.
Thank you, Mr. Chair. 3 questions, if I may.
Yeah, go ahead.
First 2 are just clarifying. Now, as I was researching this, a lot of information about the Harvard professor Gary King was brought up. This is the methodology that he created back in the 80s. Is that correct?
Correct.
Okay. The second,
it's based off of. He had several Harvard Law Review articles on it, and then it's been used in various court cases around the country. Mostly since about, I want to say 2007 was when a lot of this heated up.
Thank you. And Mr. Chair, that goes into my second question too. I just wanted to clarify that this methodology has actually gone up to the U.S. Supreme Court and been very prominent. And even though the Supreme Court has not weighed in on a yes or no specific to this methodology, that those cases have gone positively. So we're expecting to be on solid legal footing with this. Is that correct?
Yeah, the Supreme Court has, I think, unfortunately, our courts have been put in a position that's difficult. The Supreme Court has wisely said this is a political decision, and we don't want to get involved after years of grappling with this. And so the Supreme Court really mostly focuses on racial gerrymandering and stays out of the political questions related to redistricting. It is inherently political. We can try to make it apolitical, and that's kind of the awkwardness of Prop 4 at times. You're trying desperately to avoid seeing partisan data as a committee. But everyone behind me has, and everyone following this is very much aware that it has political consequences when you redistrict. And so, the Supreme Court has said, we're not adopting a standard because this is a political question. This is in the Rucha decision, and we really don't want to be in the middle of political questions if we can avoid it. Unfortunately, our courts are in the middle of it due to Prop 4, and so we're trying to, where the Supreme Court says we evaluate. We could look at these standards, but we're not going to do that because it's a political question. What we're saying is, okay, well, our courts are forced to do it. The courts have said you have the discretion to determine what the statistical method and modeling should be. And so we're taking that and trying to make it so that, every map should, I don't think the goal of Prop 4 was to push every single map in all circumstances always to a court. We want to create some certainty so that, moving forward, our courts are not in the middle of every single controversy related to redistricting maps.
Thank you.
I have one more. That was two.
Go ahead. I thought that was 2 already.
That was 2. I said 3.
Okay, go ahead.
Thank you, Mr. Chair. My last question is just whether or not the senator is aware of how many states are currently using this methodology or making decisions informed by this methodology.
So to this point, I don't think that any states have statutorily adopted a statistical model. This is kind of new territory, but we're also in new territory over the recent, in the recent 10 years or so of states either through amendment or through statute doing redistricting commissions. There's been a few out there, but this is recent and new developments in the law as to these issues. And so, and this is the first time that a statute has been adopted by initiative that includes the phrase partisan symmetry and then says, try to find partisan symmetry. And it doesn't, and that because there's all this litigation and all of these differing expert opinions out there, it is, I think it's wise for us to give the courts some guidance as to how to do that.
Thank you.
Thank you.
Before I go to our last question that we're going to take around this bill file, let me remind the committee. One, as an interim committee, we don't have to take any action on this bill file. We don't, it could come to the floor during the special session without any action from this committee. We're allowing the time in this committee so that you as committee members, other legislators, the public can understand what the debate is and whether we take action on this in a further meeting will, I think, be up to the chairs as to how we do that. But we do not have to take that action, and the final vote will be on the floor. But it is, I believe, the intent of the legislature to try to define this measure. And I think that's what we're trying to, in other words, we're trying to debate today, trying to get the information out there. Representative Owens.
Chair, I want to just open by saying I appreciated your earlier comments that being here under protest, because I understand that many, primarily in the majority party, don't see this as something that should be done, but they're complying with the court order, and I appreciate that. Some of us aren't doing it under protest. Some of us are just happy to be here. But I think either way, Mr. Chair, I think we're all here anxious to do our part in a healthy constitutional democracy. And so I appreciated your comments. Could I just clarify, Mr. Chair, is this the debate on the bill, or is this clarifying questions? Are we going to come back? I just wanted to understand.
We're going to do clarifying questions, Representative. And if we do choose to take action, I think at that point we will have debate on the bill.
Okay, well, I would like to, then I'll just ask a few questions if that's all right.
You go ahead.
Sponsor. So one concern I have, and you could speak to this, is that the court said, legislature, go back and comply with the requirements in Prop 4. The first thing out of the chute this morning is us changing the requirements of Prop 4. And specifically, my concern is embodied in line 58. And after that, it says that we're going to confine all the tests the court said to do. You're supposed to use all the best scientific, judicial, statistical methods to not favor or disfavor any party. And suddenly we're going to compress all those she's wide open. The language of the Prop 4 is wide open about what we consider. And now we're going to try to, with this bill, would constrain it to one single test. Are you concerned that about the optics of that, of saying the court says follow Prop 4 and the first thing out of the chute is we're narrowing Prop 4?
Senator Brammer.
Yeah, I'm not. I think, we clarify, and what courts are typically looking for is a legal test workable? So for example, there was a criminal law test on Finlayson from 2018. There was a case where the court overruled it, saying this test just isn't workable. The courts need workable tests, need workable methodologies to evaluate things. Now, providing clarity as to what a workable test would be is not outside of the realm of what Prop 4 said. What it is it's saying, okay, here they're saying partisan symmetry. The court recognizes that these are generalized, non-specific criteria, and invites us to say, with our discretion, we can do it. The fact that we exercise discretion does not mean that you're undermining a bill. What it means is that you're actually trying to create a workable methodology for parties to use when proposing maps. And so that's what we're working towards. We're trying to do that.
I appreciate that. But as I understand it, if I could continue.
Yeah, go ahead.
You not only have compressed the test with the bill language to one thing, providing that to the court, you're also picking a particular meaning of partisan symmetry. I guess I'm asking multiple questions, Senator, but I'm sure you can more than competently handle it. Are you aware that in the academic literature there's more than one definition of partisan symmetry?
Senator Brammer.
Yeah, I think one of the points of having laws and one of the points of the legislature is to provide clarity as to what we mean by words. Now, Prop 4 could have very easily defined partisan symmetry, could have very easily decided which tests they were going to use. Now, if your question is, are we going against Prop 4 by picking a test? I assume that would be resolved by if we picked two tests. Is that fair?
Well, I am concerned that we're condensing Prop 4.
Hang on. Yeah. Run it through the chairs.
Yeah, so...
Sure.
Go ahead.
Yes, I am concerned that we're narrowing it not only to one of the many factors listed in Prop 4, but a particular definition of that one factor, partisan symmetry. My awareness is that even Justice Kennedy in the Supreme Court has criticized this partisan bias test as the only measure of partisan symmetry. So, yeah, that is my concern.
Okay. Senator Brammer, I'm going to allow you to respond to that. And then time-wise, I think we're going to move on. In the fact that we're not going to take any action on this today, somewhere in time, the legislature will have this debate and have to define a test, multiple tests, whatever it is. Senator Brammer.
So when the court says it is the legislature's discretion to determine the best available data and scientific methods, that means, by definition, eliminating some data and scientific methods that we don't feel are appropriate here. Now, if the debate is merely you need to have more than one so that it's methods, we can have that debate, and I think that you can talk about that. But the idea that keeping it wide open and undefined and subject to everyone arguing over what was meant by the language partisan symmetry, which I'm guessing most people haven't really thought deeply about until now. And most people voting on it were not thinking deeply as to what partisan symmetry meant at the time they voted on it. I don't think that's what the court said was sacrosanct as to Prop 4. The court is specifically inviting us to eliminate, or in other words, to choose which statistical methods we should be adopting for use.
Thank you. Senator McKell.
Thank you, Mr. Chair. I'm hearing this discussion. That we're minimizing the standard, and I'm looking through your bill, Senator Brammer, and line 62 it lists the criteria. Line 64 it lists criteria A. Line 68 it lists criteria B. Line 71 criteria C. Line 72 criteria D. Line 74, criteria E, 75F, and 76G. Your bill doesn't eliminate any of that criteria, correct?
No. If you look at, for example, in line 58, which was what Representative Owens talked about and his concern, it limits it to in regards to subsection 4. Now, if you go to subsection 4, that is the portion about partisan symmetry and whether or not it favors or disfavors a specific political party. And so this is specific to that provision. It does not impact the other remaining provisions which are related to Specifically, is it geographically compact? So for example, a court is free to say, well, gosh, if you put everything into a small compact district in one, what does it do to the other 3 districts by making them enormous, and unwieldy to represent, large portions of the state? That's a different analysis than this. And so, there are all of the other criteria as to division of counties, division of cities, things like that are outside of this. This is simply so that we don't have a food fight between experts as to the statistical analysis of partisan symmetry.
Senator McKill, any follow-up?
No, thank you.
Thank you. Committee members, there are no other lights on. We are going to, I think, bring it back to Michael. You're going to give us a little further explanation after a robust debate. Yeah, let's do that, because again, this is informational. We're not promoting or discounting anything here, but we want to make sure that you understand what partisan symmetry is and isn't, and staff's going to continue with, well, I think another quick example.
Yeah, so this, again, Mike Curtis with the Office of Legislative Research and General Counsel. I'm just going to walk through a demonstration of how this partisan bias test plays out. So there's a fundamental premise here that in a hypothetical election for 4 seats, using a symmetrical map, so a map that treats both parties evenly, an even statewide vote share produces an even seat share. So imagine Party A gets 50%, Party B gets 50%. We would expect in a fair map to see 2 seats on either side. So this is sort of like the control for our experiment, right? If you think of a scale, and you want to see if you put something on the scale and it says 48 pounds, the only way to know if that's accurate is to put something on the scale and see if it actually that you know how much it weighs already, and see if the scale matches what you know, right? So that's this is our control, 50%. As Senator Brammer talked about, a partisan index. To get the necessary partisan data, we're going to look at the election results for the last 3 cycles for these 5 statewide races: president, governor, attorney general, treasurer, auditor. Let me just clarify something I just said. I said we're going to look at, and that's not accurate. Someone else looks at this data and creates the partisan index and then runs this analysis. This is not something that happens in the creation of a map. It is after a map is created to go back and analyze that map. So in this example, I've used a hypothetical statewide vote share for 2 parties, 61% and 39%. Just to note, just as Senator Sandel said earlier, all of the numbers are hypothetical, and it's not real world. And of course, in real world, you would have more than just 2 parties. You'd have independent votes, and so these wouldn't add up to 100%. But we're just doing 2 parties that add up to 100% for ease of demonstration. So that those 15 races that are averaged out for our statewide vote share, that data is available to us down on the census block level, so that when a map is drawn, after the fact, after a map is drawn, you can go and analyze what the vote share is expected to be based on that average data in that proposed map. So 4 hypothetical districts on this hypothetical map, and based on the vote share down inside of those districts, you would get these 4. So remember, 50% is sort of our control group, right? That's how we know if it's 50%, we know what the outcome should be. So the next step is to then calculate the difference between the average statewide vote share for each party and 50%. So in this case, it's 11%. You then subtract the difference from the vote share in each of those prospective districts on the proposed map. So we'll do that quick calculation and adjust for that 11%. So again, 50% is our control group. We know what should happen on an even map if both parties get 50% statewide. So now we're assuming that 50% statewide vote share happens and seeing how that affects each district's vote share. Okay. And then you examine in this adjusted hypothetical 50-50, it should come out as 2 seats on either side. And in this case, it does. And that is evidence that the map is symmetrical. There's several examples that we can walk through, and I'm not sure if you want to take the time to do that. Maybe I'll just take one more.
Yeah, let's show one more.
Okay.
I think it's important for comparison.
So in this example, we're using the same statewide vote share, 61 and 39, but we have now a different map. So the lines on the map have changed. So the vote share inside of each of the districts is slightly different, but same process. So we get that 11%, and you then go and you adjust each district by that 11%, because the goal again is a 50-50 election as a method of evaluating whether that map is fair. In this case, you count up districts for either party, and you see that one party wins 3 seats, one party wins 1 seat, which suggests that the map is not symmetrical. So in this case, it's not the vote, but the map that is forcing the outcome of the election, if that makes sense. Okay.
Yeah. Hopefully that may have been helpful. At this point, Representative Owens, is your question to this process or?
Yes, it was a comment on the first hypothetical chart.
Okay, go ahead.
Thank you, Mr. Chair. So if you look at that, this is my objection to using this test, and I just wanted to make a brief point while this hypothetical is up on the board. I think the committee deserves to know that this is a hotly disputed issue in the academic literature and in the courts. It's been called counterfactual by Justice Kennedy in the Supreme Court because it makes a hypothetical that has no bearing on reality. And this is the chart that shows the no bearing on reality. You see, look at the real world apportionment in the hypothetical, okay? The dominant party getting 73, 55, 70, and 55 going clockwise around the chart. And then it just so randomly just narrows the parties by 22 points. There's no real world hypothetical where there's a partisan shift of 22 points for any reason. And so it shows in the hypothetical that the minority party can win in 2 of those scenarios where there's a randomly assumed 22%. There is no real world scenario where you're going to see this 22%. So I wanted, while this chart was on the screen, Mr. Chair, to point out the unreality of this hypothetical. I spent 2 or 3 hours, and Councilor Curtis was exceedingly gracious and patient with me, trying to help me to understand why there would be any relevance at all to this method that assumes this random 22% shift in points. And this has been specifically criticized as a valid measure of gerrymandering when it's applied in a lopsided state, where it's politically lopsided. It has more relevance in other statistical scenarios. I just wanted that to be apparent because this shows theoretically that somehow this minority party hypothetically can win 2 races. But where does the assumption that there's going to be a 22-point shift in the voter? I don't understand it. In the real world, the dominant party is going to win every one of those 4 seats.
Okay, thank you. I think that that is the debate that we're having, and we're going to continue to have as what the legislature thinks is the test. And I'm sure that there are many examples on the other side that we've heard about that would lead us to a debate, because I don't think that's all the way clear. So I appreciate that. We are going to now move to number 4, presentation on redistricting methodologies and proposed maps. The committee is here at this point because we quite honestly have asked Mr. Sean Trendy to develop through a system that he has maps that are compliant with the 7 measures of Prop 4. We have employed him actually to give us those maps. The maps that you've seen in the public will show you that there are only a certain amount of ways that you can draw where the population center is so concentrated, maps that comply. We have tried as chairs to represent a couple of those types of maps, those geographical, those images tend to change based on what we can do under Prop 4. And it will be the legislation or the legislative prerogative to then choose one map that meets the measures of Prop 4. And by doing that, I think the legislature is going to have to choose between those maps based on legislative preferences. So I'm going to ask staff if we've got Mr. Trendy on board. And I'm going to ask him to introduce himself, tell us about himself, give us his credentials and background, and we'll turn the time over to you, Mr. Trendy. Also, when we do remote, will you tell us where you're at?
Yes. Can you all hear me?
Yes, we're good. Thank you.
All right, great. My name is Sean Trendy.
Just a minute. I've got a point of order. Senator Escamilla, state your point.
Thank you, Mr. Chair. I just want a clarifying question before we go to the expert in terms of process, because you were giving a process question. You mentioned, I want to make sure it's clear on the record that you mentioned we retain the expert. Can you explain for what purpose was this expert retained in terms of the exercise for the entire committee? Yes. I think that's a fair question, Mr. Chair, before we go to him.
I'm going to move to council. Michael, do you want to take that, or do you, John, do you want to take that? Which way? Either way. Let's go to Michael.
Okay. So Mr. Trendy was retained as an expert witness for the litigation. He's also separately contracted with the Office of Legislative Research and General Counsel to do map analysis on any maps that any of you ask us, you the legislators ask us to analyze. And so on any maps through that side that we've had analyzed, they've been delivered anonymously. They're anonymized with just a number identifier. So Mr. Trendy is not aware of who he's scored maps for or hasn't in that regard.
Okay.
Yeah. Thank you,
Mr. Chair.
Okay. Sorry for that. Mr. Trendy, go ahead.
Yeah, my name is Sean Trendy. I'm testifying here remotely from Delaware, Ohio. It's a suburb of Columbus, just to the north of it. And I'm delighted to have the opportunity to speak and hopefully help to clarify some issues that have presented themselves in the testimony. I received, for my educational background and qualifications, I received a bachelor's degree in history and political science from Yale University. I then got a JD combined with a master's in political science from Duke University. I did a federal clerkship on the 10th Circuit and practiced law for 6 years before transitioning over to become the senior elections analyst at Real Clear Politics. I, in 2016, enrolled in a PhD program. At the same time, I earned a master's degree in applied statistics from, and I apologize, but I am required to say it this way, The Ohio State University. I also received my PhD finally with dual concentrations in political methodology and American politics in 2023. As a part of that PhD program, my dissertation in part focused on redistricting simulations and their use in evaluating maps. I've been retained as an expert witness in dozens of cases involving redistricting matters, but the thing I'm most proud of was I was appointed as one of the co-masters by the Supreme Court of Virginia with Dr. Bernard Groffman from California, to draw that state's House of Delegates, state Senate, and congressional maps after their independent redistricting commission deadlocked. We were able to produce those maps in their, I believe, the only maps in the South that haven't been challenged as either a political or racial gerrymander or violating the Voting Rights Act. So with that background, I'm happy to take your questions here.
Thank you. Let's begin by asking, have you reviewed the standards and requirements in Proposition 4?
I have.
Okay. I'm going to turn to my co-chair who also has a couple of questions.
Thank you. And would it be appropriate to refer to you as Dr. Trendy? I just want to make sure you've got a lot of degrees there, so I'm just making sure I have the right title.
I'm not picky about it, but I suppose it is technically Dr. Trendy.
Okay, thank you, Dr. Trendy. Can you help us understand what those standards and requirements are under Prop 4, but then also the methodologies that the federal government has also established for us?
Yes, so, above all else, of course, is the federal Constitution and federal law. And so this starts out, the standards start out correctly with population equality, which is a requirement under the 14th Amendment, of course. There's a little bit of wiggle room for state House and state Senate districts. The court has more or less signed off on plus or minus 5%, although there's some case law suggesting that that isn't a safe harbor. You should still try to keep it smaller than that if you can. But for where we are here today for congressional districts, there really isn't much wiggle room. The court has occasionally signed off on larger deviations, and by larger deviations I mean tenths of a percent. But for purposes of keeping a map litigation proof, the best bet is to try to keep the population deviations as small as 0.
Great, thank you. As part of that, I think, the main, as we look at Prop 4, it talks a lot about divisions of municipalities and the divisions of counties. I live in Salt Lake County, and this is one of the questions we get asked a lot, but is there any way to not split Salt Lake County when you draw congressional maps in Utah?
No, so Salt Lake County is the only county where, I'll define a piece of jargon first, which is the ideal population. And the ideal population is simply the state's population divided by the number of districts. And so that is what you're aiming for if you're trying to zero out a map. In Utah, there is one county that is more populous than the ideal population standard, and that is Salt Lake County. So it's not possible to comply, A, with the U.S. constitutional requirements, and B, with the top tier requirements of the proposition, which is minimizing population deviations while still keeping Salt Lake County intact.
Thank you. Thanks for clarifying that. Another question that's come up is we really are hyper-focusing on and making sure we are in compliance with Prop 4 around the divisions of cities and counties, is we do have, I believe it's 4 cities that actually cover 2 counties. So like Bluffdale would be an example of one. How do you, when you're doing that analysis, treat splits where a municipality crosses a county boundary? I think it's Bluffdale, Santaquin, and there's 2 others that I'm forgetting right now. Draper and Park City. Thank you.
Yes.
Yeah.
I've spent some time getting familiar with those places.
I'm sure you have.
It's a good question. It's something that we struggle with in other states, where you're supposed to keep a city intact, but sometimes cities aren't contiguous. And so how do you deal with that question? Fortunately, here the Utah Constitution is clear about the ordering. You rank keeping municipalities intact over keeping counties intact. And so when I evaluate these maps, my approach has been if a county is split, but only by keeping those 4 cities intact. So if you have, if a district kind of spills over into Utah County to keep Draper or Bluffdale intact, I will not count that as a county split because the Utah Constitution privileges municipal boundaries over county boundaries.
Can I ask a clarifying question? Is it our Constitution or is it Prop 4 that requires that? You've mentioned the Constitution requires that.
So I think that would be a misstep on my part then. When I talk about population equality, that would be the U.S. Constitution. But when we're talking about the privileging of municipalities over county boundaries, that would be Prop 4.
Thank you.
Thank you. I think that's really helpful as we've really tried to be mindful of that. And I know our committee will be very thoughtful as we review the maps. The other component and factor that's important when we look at methodology is compactness. So for those of us who aren't all experts here or maybe didn't serve on the previous redistricting committee, what are the ways to measure compactness? And is there an acceptable level of compactness or is there this fluidity that is allowed?
Boy, so this is a answer or a question that I could go on for probably an hour. What exactly is compactness? It's something that we struggle with, for example, with the Voting Rights Act, which requires that a district be reasonably configured, and compactness is usually part of that standard. There have been various attempts to mathematically categorize compactness. There are things such as the REOC score. The REOC score, basically, you take a congressional district and you draw a circle around it, or realistically, the computer draws a circle around it. And it asks what percentage of that circle the district would fill. So if you have a REOC, when you see on some of the reports I've generated a REOC score of 0.23, that means that the district would fill 23% of the minimum bounding circle. Practically, what that means is as a district becomes increasingly distended, if you draw a long, narrow district, it'll fill less and less of that circle that circumscribes it, and so the REOC score will fall. So REOC scores punish lengthy districts. Polsby-Popper scores is another one. Polsby-Popper scores say, well, that's great and all, but what about a district that might not be distended, but it has a lot of little arms that reach out or inlets? This is particularly useful for gerrymandering because one of the indicators of a gerrymander, racial or political, can be a small arm that reaches out and grabs some area or party. And so what the Polsby-Popper standard basically says is, okay, let's take that congressional district and kind of stretch it. We're going to smooth out all the little jagged edges until we have a circle again. So it's going to be a circle with the same perimeter as the district. What percentage of that circle would the district fill? So Polsby-Popper score of 0.15 would tell you it fills 15% of that district. So the Polsby-Popper score is basically telling you how many kind of arms and inlets a district has. Now, go ahead. I'm sorry.
Oh, no, I was sorry. I'm an interactive talker. So I was just like, okay, that makes sense.
So and there are multiple. There's convex hull. There's I know it when I see it scores. There are literally dozens, if not hundreds of scores that have been proposed that all get at different kind of aspects of compactness. One of the downsides of Polsby-Popper is that if you have a command to follow natural boundaries, as you have in Utah, some of those boundaries are not regularly shaped. So, for example, Colorado River / Lake Powell. If you're following the boundary on San Juan County, you follow all the meanders in that river, it's going to expand your perimeter. And so even though the district hasn't done anything kind of sketchy, it's still going to get a worse Polsby-Popper score because you followed that river boundary. There is also something that the Supreme Court has endorsed. A lot of people don't really like it, but it's just simply the eyeball test. Just look at it. Does it look weird? Humans are better at this stuff than we think we are. But it also works with, and I think you alluded to this, one of the major downsides of those scores is that there isn't a 5% cutoff or a 10% cutoff. No one can really say REOC score of 0.2 good, REOC score of 0.19 bad. And by the way, I should have clarified, a high REOC score or a Polsby-Popper score is good. A low one is bad because as the scores increase, it means you're filling more and more of those circles, and so you're more and more regularly shaped. So they're nice heuristics, but they don't give us an answer, a clean answer that we would like of, yes, this one is not compact or this one is compact.
Thank you. I think that's helpful. And leading into the next, and I'll just say I used to work for a congressional office right after I graduated. And some of the maps that I've seen, I thought this would be impossible for a member of Congress to see their constituents from a pure transportation perspective. And so compactness is one way to measure a map, but then also contiguity and the ease of transportation. You've mentioned we have some geographic features like the Colorado River. We've got a mountain range running through us. So is there actually a recognized standard for ease of transportation other than just looking at it and saying, holy crap, that's going to take 23 hours?
Again, unfortunately, not. We might talk about redistricting simulations there, and there are some things you can do to guarantee that the maps produced will follow roadways and not, you wouldn't have to climb across the Wasatch Front to get to your other constituents. But as a general matter, when evaluating these maps and generating some of them, there's kind of 4 ways into Salt Lake City, right? You can go I-15 or I-80. And there's some minor roads that you can take through the mountains, but those, if you're going to Tooele County or you're going to Summit County, those are going to be the major ways you do it. And so we tried to make sure that if a district crossed either of those boundaries, that it had an interstate connecting them. We tried to make sure that you didn't have Box Elder and Tooele in the same district unless it came all the way around, so that there would be a connection there that you can realistically traverse. We tried to make sure, and I think we successfully made sure, that you didn't have to do an Evel Knievel across the Colorado River in southeastern Utah, that you went through the one bridge, and I guess it's not the Colorado River, it's over the Green River, to connect there. So we were attentive to those concerns.
Thank you. I think that's helpful. So, and it sounds like there's a lot of debate around this, but is drive time a valid metric or something to consider?
We didn't build that in. We looked at the major roadways that connected the district. I know in Utah that just drive time gets really, really tricky because southern Utah has some very difficult to reach places, as I think Rich County is even from Salt Lake City very difficult to get to. So that's one of those things that if a committee wanted to look at it, they could, but I think it's a hard metric to build in, and you certainly wouldn't want to look at it in isolation.
Great, thank you. The next standard that I just want to make sure we have you flesh out, and there's just a few more, and I think my co-chair has some questions we'll open up to the committee, but when we talk about preserving traditional neighborhoods or communities of interest, I know when I was on this committee last time, there was great debate around this. Can you identify some of the communities of interest? Is this purely subjective, or what have the courts have said on this?
So this is actually one of the topics of my dissertation, and communities of interest.
A little teaser there. Okay.
Thank you. Every PhD loves to brag about his dissertation, but the communities of interest are something that I think people intuit at a certain level, right? Like Harlem is an area, if you're drawing in New York, you might want to be attentive to. It's a historic neighborhood. If you're drawing in Virginia, we wanted to keep the Shenandoah Valley intact because that's a community of interest. It's also, though, something that, because it's poorly defined, can be used as a post hoc rationalization for a way a map was drawn. So when I was evaluating the maps, I wanted kind of high-level, well-established communities of interest. And so we looked at things like trying to keep the various interstate corridors intact. We tried the Indian Native American reservations are generally pretty easy because they tend to be contained in a single precinct. The one exception is the reservation in Duchesne, Uinta County. I think it's the Uinta and Ouray reservation. And so we did a little extra work to make sure that stayed intact in the maps. But tried to make sure that college campuses weren't split down the middle, that military reservations were kept intact. But beyond that, there are so many. I think I looked at the Independent Redistricting Committee's report. I didn't have access to what they had identified, but they had hundreds of communities of interest. And because redistricting is a complex matter, it always involves robbing Peter to pay Paul. I don't think there's a way, and I don't think even the IRC accomplished keeping all those intact, but we try to keep that in mind. One final point is that one thing political scientists have been pretty consistent on is the notion that city and county boundaries often reflect communities of interest. So by requiring counties and municipalities to be intact, that community of interest concept is kind of hardwired into Prop 4's language.
Thank you. I think that's really helpful because that's something we've even as legislators and colleagues debated, well, how do you define a community of interest? So thank you. The next standard that we have before us is this idea of following natural and geographic features, which I think you've done a good job laying that out and how you've tried to look at that. And I guess my other question would just be, how do you maximize boundary agreements with different types of districts? So you've got obviously legislative maps, school districts. How does that all play into here? And they're not drawn under Prop 4 standards. Does it make sense to compare those here? If you could flesh that out, that'd be really helpful.
Yeah, so at this point, we were looking at the seventh consideration. And we're also, I think when you're looking at the state house versus the state senate, there's more of an argument for keeping things coterminous. Frankly, if you're comparing 4 congressional districts to a large number of state house districts, you're gonna naturally respect a lot of those boundaries because a congressional district is going to tend to include 15 state house districts in total. So especially given that those districts were not drawn, to my understanding, under the Prop 4 criteria, it creates, in this unique circumstances, a bit of an apples to oranges comparison.
Okay. Thank you. And then I guess I would just love to get your input. We've talked about the importance of in the final component here, right? The purposeful or undue partisan influence and specifically measures of partisan symmetry. Can you walk through that analysis and what you think about the partisan bias test that we just had a robust discussion on, but I would just love to get your perspective as an expert on this.
Yeah, so I think there's 2 important parts of what you laid out, which is the purpose test and the undue favoring test, because those really they can be similar, but they're kind of distinct concepts. The purpose test is if you were drawing without any political data, would this map kind of look like what you would expect to produce? Is it drawn without trying to help Republicans or trying to help Democrats? The standard issue way of evaluating that is, and I heard some discussion about this earlier, with computer simulations. And so if you look at the sheets for maps that I've produced, there are comparisons to simulations, and I've used multiple simulation, they're called ensembles, the maps that are generated by computers to conform with various requirements. There was a set that was produced by Christopher Kenny at Harvard University quite some time ago, but nevertheless, in this census cycle, so the first place I looked was those maps to make sure that maps would kind of conform with the partisan outcomes of his simulation, right? Because his is drawn by a computer. There's no question that there's no partisan intent in the maps that computer generates. And so if the map that's being submitted has partisanship that's similar to that neutral ensemble that he drew, then I say it passed. If it's outside on either direction, then I says, well, it looks like this was drawn with partisan intent. The second and third sets are simulations that I generated. The first was, it just has like the first 3 requirements of equal population, municipal splits, and compactness. And so we compare it to that ensemble. And then the last one, and this was time consuming and hard to do, but it removes the possibility, you have to kind of go through and hand code the possibility of crossing mountain ranges without a connector road. It removes the possibility of crossing major rivers without a bridge, and tries to force the map to conform. It freezes together the Native American reservation in Duchesne and Uinta counties, so that always has to be kept together. And it conforms with kind of 4 and 5, 6 of the requirements from Prop 4. So with those 3 simulation sets, we were able to determine whether the map had partisan intent. It's an open question. There's a second set underneath that you'll see that mentions culled. It's an open question whether you should remove the maps from the simulation set that would fail the partisan bias test, since those maps would be illegal under Utah law. So there's a second grouping that removes asymmetric maps. The second thing that you mentioned is the unduly supports or aids a party test. I was a little surprised when I saw the language of Prop 4 because it didn't do what I had kind of thought Prop 4 would do. It specifies partisan symmetry as a measure, and I think there's been some confusion about various tests that could be utilized. There have been many tests. So partisan symmetry, I think most political scientists agree, for the outcome test, does it have the effect of favoring a party, is kind of the gold standard. And it's kind of the like do unto others as you would have them do unto you standard. So if you get an outcome in a 65% election, is it the same thing you would get in a reciprocal election on the other side? It's much more useful, in my view, and I think most political scientists would agree, for House and Senate chambers, where you have a large number of districts to keep track of. With 4 seats, it's written into the law, so it's what we use. But and I think that's why you kind of get some of the confusion about how this applies in practice. But the most important thing is that over time, political scientists, and there's a famous article by Jonathan Katz, Gary King, and Elizabeth Rosenblatt that demonstrates that the only test that truly measures partisan symmetry is the partisan bias test. People have suggested over the 2000s and 2010s, well, maybe the efficiency gap does it, or maybe mean median does it. But the only test that really tests partisan symmetry is partisan bias. In my view, it's not an option, since the statute specifically says to include tests of partisan symmetry. I don't think there's an option to use, to not include a partisan bias test.
Thank you. I think that's really helpful. And I think as well, when we talk about the efficiency gap or maybe other metrics, I think to your point, and maybe just correct me if I'm wrong, there's a difference between proportionality. There's a difference between partisan symmetry. I think that words matter. Can you walk through, maybe, are there states that have a different language used? You said you were surprised when you saw partisan symmetry in Prop 4. What are you used to seeing in states that pass, say, an independent redistricting commission?
Well, a lot of times they just kind of leave it open. There's language: the map shall not have the purpose or effect of favoring one party or another. And that does kind of leave the door open potentially to some of these other measures. I think, even if that door were left over here, something like the efficiency gap doesn't work well with 4 districts, and it doesn't work well in a state with heavy partisan lean. You have states like New York just as a pure purpose test. It doesn't have an effect prong. You have states where Supreme Courts have interpreted the elections clause, for example. North Carolina did this for a while before they overturned it. And the courts have kind of said, use efficiency gap and mean median, for example. I don't think I've ever seen a state that specifically wrote in partisan symmetry. Again, I kind of agree with the political science viewpoint that partisan symmetry is a good standard in general, but by doing it, I think one of the consequences is that partisan bias is a test that has to be considered. I do want to clarify, and this is just kind of knowing how these things work. When you only have 4 congressional districts, if a state is symmetric, if there's 2 districts on either side of the statewide average, the mean median gap is almost always going to be very small, and the declination, which is another measure, will always be very small. It's just kind of the unique nature of only having 4 seats. So if someone wanted to use a different measure, I would be surprised if mean median or declination or whatever showed poorly. But that King, Katz, and Rosenblatt article walks through all of these measures and shows why they don't use symmetry, including proportionality.
Thank you. I think that's really helpful. And thanks for walking through those Prop 4 standards with us. I'll turn the time back over to my co-chair.
Dr. Trendy, appreciate and sorry to take up so much of your time, but we're trying to get the committee to understand what it is and how we're looking at this. Going back to the 2021 maps that the legislature passed and the Independent Redistricting Committee, and by the way, the acronym IRC is the Independent Redistricting Committee when we refer to it that way. Have you looked at how those maps fare under Proposition 4? They were developed under Senate Bill 200, different criteria, but if we were to look back and compare those now with how they fit under Proposition 4, have you taken that opportunity? Has that been something you have looked at?
I think they would all have problems. Certainly the 4-way split of Salt Lake County in the enacted map, and the addition, I think Juab County gets split and 2 other ones. That could be minimized. I think if you look at the IRC maps, they fail. All of them fail the partisan bias test. And I believe, I would want to check my notes, but I believe they also fall outside of the bounds of the redistricting simulations. They show indications of maps being drawn with partisan intent. So I don't think any of those maps are live options under Prop 4.
Thank you. Co-Chair, do you have another question? Okay. Have you looked at other maps through the lens of Proposition 4 standards, and what instructions were you given from the chairs?
Well, so maps that have been proposed, I've evaluated them. If someone has proposed a map and gotten the little 1-pager kind of summarizing the aspects of the map, that was something that was done using the techniques that I have that I've described so far. And as maps have been considered to be proposed to the committee, they've been evaluated using those standards as well.
Thank you. I believe we're probably best now if we've got our staff ready to pull some maps up. We'd like to have you, if you would, walk through the 5 maps that the chairs have identified meet the 7 standards, and also have at least some different shape files, if I can say it that way, and when we can kind of identify what they are and how they best flesh out, and then obviously the legislature is going to determine a choice between the maps that are presented. But let's see if we've got. Should we start with the E,
Yeah.
if we can? Now, I'm going to apologize in advance. The software system that we're using really needs an update, and it occasionally crashes because this is a huge amount of information that we're asking the system to process. If that happens, just give us, usually takes about 30 or 40 seconds to reboot the system, and we'll go from there.
Dr. Trendy, while it's pulling up, if you can as well, so you've done an analysis on each of these, let us know what the partisan bias test is, and then how you think it fits with Prop 4 standards. That'd be awesome.
Okay, so this is Map E. You can see that starting from, first off, I think under the eyeball test, these are reasonably shaped districts. Their scores, when you look at them for Rioch and Polsby-Popper, are not outlandish, I don't think by any stretch, especially for a state like Utah that has some irregular boundaries that you can follow. You can see how following some of these city boundaries in Utah County adds Polsby-Popper problems, but that's just unavoidable. It does minimize the county splits and has very few municipal splits as well. The districts are completely equipopulous, and the partisan bias of the map is zero. At 50-50, it creates 2 Republican seats and 2 Democratic seats.
Okay.
You can also, you can also see, if you look at Salt Lake City, how to get to Tooele County, it does have that connector just south of Salt Lake with the interstate. And likewise, going up District 2 into Davis County isn't a problem at all. Likewise, and because the Utah County border isn't crossed for Salt Lake County, there isn't a concern there either.
Thank you. Let's move to D, map D.
While we're pulling that up on the option E, did you happen to look at what the drive time would be on that bottom district that takes up the majority of the bottom of the state?
No, drive time wasn't something that I looked at.
Okay.
I think no matter how you do Southeast Utah, it's difficult to get around there.
Okay.
And because of how Utah's configured, because the rurals, outside of the 4, Weber, Davis, Salt Lake, and Utah County, the remaining counties don't add up to a complete congressional district. So no matter what you do, you're going to have to cover a lot of geographic area in at least one of the districts.
Thank you.
Thank you. We currently have map D before us. Would you kind of describe a few of the things around this map?
Mm-hmm. So I will just say in advance to kind of shorten things, all of these maps are zeroed out, so they're equally populated. All of them minimize county splits or keep them very low, and same with municipal splits. This is a little bit of a different look in that it tries to follow the Colorado River boundary. So now that that district, that area, San Juan County is accessible from the north. Obviously, that's a long congressional district, but if you're really going to follow geographic boundaries, there aren't but so many ways you can configure things. If we go into Salt Lake County, zoom in on the urban areas, you can see again, it's got some strange shapes because we're following city boundaries, but it does keep Salt Lake City intact. It makes sure that you can cross over into Tooele County and Davis County easily via interstate. And so overall, it's intended, and I think does comply with the Prop 4 requirements. It is a symmetric map.
Thank you. Let me make sure we're clear on, and I think we have identified this, but let's just make sure one more time that anytime you talk about applying the symmetry test, the maps were never developed with symmetry in mind. The symmetry test was only applied after a map was developed under the standards. Is that correct?
That is 100% correct.
Okay, we want to make that very clear. Now we're going to go to C, map C, and maps A through C have some, quite honestly, a lot of the same. If you look at the eye test, so to speak, the same configuration with some adjustments. Could you talk about, while these are coming up, why those adjustments tend to center around the population center, and then describe, this is map C and what it does?
Yeah, so again, there's not but so many ways, especially if you're trying to minimize county splits, that you can divide this map up, particularly if you're trying to pay attention to population corridors and that sort of, and keep your map your district's compact. And so that District 1, if you're not going to let it cross over across the Salt Lake Basin or the desert into Tooele County, it's going to come over into Cache County, down into Weber County. And then you kind of have a choice. You can go into Davis County and the population fills up really quickly, or you can kind of do what the last map did and go around the edge. And so because of this, because of the requirements and because they are pretty constraining, the basic configurations, you kind of see a lot of patterns in them. But again, this is compliant with the early, the kind of high level requirements of Prop 4. Obviously, District 1 here is about as easy to get through as that area of the state can be. Tooele to the western portion of Salt Lake County is easily accessible. It includes the interstate connector from eastern Salt Lake County into Summit County, and then the rest of the map in the southwest kind of follows that, I guess, I-15 corridor.
Thank you. Let's pull up map B. I believe this is it.
Okay, so map B is another one that maintains that basic configuration in northern Utah for District 1. It has the Tooele County to western Salt Lake City. It goes a little western Salt Lake County. It goes a little bit deeper into Salt Lake County along I-80, and then it has more of a split of Utah County kind of down the center. But again, making sure that there are roadways that connect it easily to the rest of the district. It is a symmetric map as well.
Okay. Thank you. Let's go to A. Go ahead, Doctor.
Yeah, so this is, and some of these basic configurations look the same, but when you really zoom in to the split in Salt Lake City, or Salt Lake County and Utah County.
Give us just a second. Now we're zooming in. There we go.
Yeah. So now you can see, if we were to do that on the other maps, there are differences in the way that county is split. But again, this keeps obviously Draper together. It splits Salt Lake County, puts Salt Lake City into the Tooele County district, and otherwise, you can get from Salt Lake County to Summit County easily. You can get from Salt Lake County to Tooele easily. The District 4, as easily as you can traverse southern Utah, I believe it makes it possible. So again, this is a symmetric map. They all fall within the ranges of the computer generated maps. So they are Prop 4 compliant. And because we're talking about 4 districts and because they are symmetric, I am quite confident that if you did want to use something like mean, median, or declination, which I emphasize isn't a measure of symmetry, those would be small scores just because of the nature of the math when you only have 4 districts.
Thank you. Again, committee, just confirming that these are all maps that Dr. Trendy sent us and developed. None of these maps were drawn by anyone in the legislature or any individual in the legislature. These are all maps that we gave him the parameters of Prop 4 and asked him to develop. Is that correct?
That is correct.
Okay. Thank you. I'm going to open this up, Dr. Trendy, to committee questions. We're going to first go to Senator Escamilla.
Thank you, Mr. Chair. So Just thank you, Dr. Trendy, for your time. I'm trying to follow on the partisan symmetry discussion because, there was a lot of questions and answers at the beginning of your presentation. You did mention, and I'm sure you've probably seen, in terms of whether we codified, which is important, the definition of partisan symmetry by utilizing the, one method, which is partisan bias. You mentioned multiple times that you don't feel comfortable with a median mean difference. Just to be clear, you have used that in other cases, correct? I mean, it is a well-known, recognized method.
So I don't think it's, to answer the second part, yes, I've used it before. I don't find mean median to be terribly objectionable. I think it's better for legislative seats where, focus on that middle seat, which gives control of the legislature, is particularly important. But it's been used for congressional districts. I think the issue with mean median, quite frankly, is just that it doesn't test symmetry. And again, when you can kind of mess around with the math, but when you only have 4 districts, if a map meets that partisan bias standard, the mean median gap is going to tend to be very, very small.
Thank you. Follow up? Yes, go ahead, Senator.
Thank you. Just to be clear, you said it doesn't measure symmetry, but it is considered a standard to measure partisan symmetry. So am I conflicting those two statements? Can you help me clarify that?
Right. So a lot of these measures were developed in the mid 2000s following the development of partisan bias, the introduction of it in the LULAC case, and Justice Kennedy had his critiques of partisan bias, but he seemed to like the concept of symmetry but thought there had to be more. So these various different tests were introduced in the 2010s that claimed to measure partisan symmetry, and it's just kind of aside from partisan bias, they haven't panned out. Again, there's this article from Katz, King, and Rosenblatt, and again, I don't mean to throw shade at Dr. Rosenblatt, but Drs. Katz and Drs. King are extraordinarily well-respected political methodologists that prove that these tests don't really measure symmetry, that it's the partisan bias test that you look to if you're trying to measure symmetry.
Thank you, Mr. Chair.
Thank you.
Just a follow-up question.
Go ahead.
Thank
One
you.
more.
And sorry, Mr. Chair, he gave a lot of information at the beginning of the part, so I have all my notes here. So to be clear, because like you mentioned, you've used in Virginia, the median mean process, right? Mean median difference. I think in New York, another one that was used is a gerrymandering index, which is not a symmetry piece. It's just another measure. And Prop 4 very clearly states that we have the opportunity. I mean, it's asking us to use the best available methods beyond partisan symmetry. So will you think as an expert that in Utah, following Prop 4, Section 4, subsection 4 of Prop 4, that we should utilize other methods beyond partisan symmetry?
So we are using, I guess there's a couple parts in there. We are using measures beyond partisan symmetry because we have the simulations and we're guaranteeing that maps fall within the 95% interval of a ensemble of maps that were drawn without respect to partisanship. I have used mean median before, and like I said, I don't find it terribly objectionable, but the Virginia code doesn't have a symmetry standard written into it, which would have, I think, changed. I can't speak for Dr. Groffman, but I think he has been a co-author on some of the partisan bias pieces. If that standard had been written in, we would have used partisan bias more prominently. As for the gerrymandering index, the gerrymandering index is is a tool for summarizing simulations, and so it is tied in with the simulations. Because here in Utah, I think most of the focus is on that most Democratic district. I wouldn't use the plan-wide gerrymandering index, and so we look at the 95% interval of the most Democratic district in the ensembles to measure whether there's compliance with the intent prong or the purpose prong of Prop 4.
Thank you. I've got a question from Representative Roberts next.
Thank you, Mr. Chair. Dr. Trendy, if I was to be a political science student in a political methodologies class, what would the textbook definition of partisan symmetry be?
The textbook definition of partisan symmetry would simply be at different points, and this is going to get a little gobbledygooky, but at different points on the votes to seats curve, opposing points on that votes to seats curve, do you get equal results? So take the map back to 50-50 to see what a neutral election looks like. If you move 3 points to the right and the map gives Republicans a certain number of seats, is that the same number of seats as you would get if you were to move 3 points to the left? Kind of the most straightforward way to measure it is by just looking at that 50% mark and saying, does this result in the same number of seats for Republicans as for Democrats? Because of the nature of just having 4 districts here, if your map is symmetric at 50%, or if you prefer, if you don't want to go into the hypothetical world, if your map is symmetric at that statewide average, if there's 2 seats above the statewide average and 2 seats below it, it's going to tend to be symmetric across the votes to seats curve.
Thank you. One more follow-up.
2, is that okay?
Yeah, go ahead, Representative.
I'm trying to understand how widespread the consensus is amongst the academic community around that definition. And I don't have a sense, but I'm sure you've got a better sense. Just give me a flavor for, is there much dispute over that definition in the academic community? If I were to, meet with a dozen or a couple dozen different political science professors, would they define partisan symmetry the same way that you've done?
It's hard to get political science professors to agree on much of anything. I do think the most important thing is at kind of a higher level. I think most would agree that when you're trying to determine whether a map produces good outcomes, that partisan symmetry is the way they'd like to see that measured, at least as long as you're having single member districts. There have been different proposals on how you create that votes to seats curve, some of them much more complex than others, but they all boil down to that basic idea, honestly, golden rule of politics, do unto others as you have them do unto you. At a 50-50, that's actually from the Katz, King, and Rosenblatt article. If you were at that 50-50 mark, would you get a 50-50 split election? And I think there would be widespread agreement on that.
Thank you. One more follow-up?
One more. And lastly, why does the partisan bias test, in your opinion, meet the definition better than the mean median test of partisan symmetry? Help me understand the mechanics, the details for why you think the partisan bias test does a better job at meeting the definition of partisan symmetry than the mean median test.
Because the mean median test only looks at one portion of that votes to seats curve. It looks at the average at the median district, or when you only have 4 seats, the average of the second and third district, and compares it to that statewide average. It doesn't look at what's happening beyond that. And so you could actually have a asymmetric map that's just narrowly, like you barely have 3 seats on the high end of it and a 4th seat on the low end of the statewide average, that would still score fairly well on mean median, but would fail the partisan bias test. So the mean median, if you're willing to say the mean median has to be small and not 0, then the mean median test isn't going to always give you a symmetric outcome. I'll also frankly say that Jonathan Katz and Gary King are smarter than I am, and if they've taken the time to prove it and get that peer-reviewed and published, I give that a lot of credibility.
Thank you. We've got 2 two additional questions, and I'm going to announce right now, when we get done with these questions in the committee, I'm going to look for a motion to recess for a minute to kind of let staff get up, move around and stuff before we come back to public comment. So just so you know, that's coming after our two questions and anything else from Dr. Trendy. Representative Owens.
Thank you, Chair. I have more than just one or two questions. This is the heart of the concern, that this issue that we're talking about, and I'd like 3, 4, 5 minutes to be able to ask some follow-ups. Would that be acceptable?
Yeah, go ahead.
Appreciate that. Dr. Trendy, you said you looked at some Harvard ensemble of cases that were done by Dr. Kenny. Is that right?
Yes.
And that was a set of 5,000 maps?
6,000, I believe.
And those maps were drawn by computer without regard to party, right?
Correct.
And that's easy for a computer to do that, right? You can put in the algorithm, you can say don't look at party, you can say do look at whether you're splitting municipalities and keeping communities of interest together, right? And you set that up in the computer, and it's just a stroke of a key to draw hundreds or thousands of maps.
That's a bit of an oversimplification of the work involved, but yes, you can make the computer do that.
And that ensemble of 6,000 maps, almost all of those showed the minority party in Utah getting a majority of one of the 4 districts. Isn't that correct?
I don't think that's right. I think using the index that they used, which is different than what's employed here, you get like 30% of the seats. So 30% of the maps had 4 Republican seats.
Okay, we'll look at that later. But then you're saying the remaining portion, 70%, had a Democratic majority seat.
I think that's right.
I'm gonna take the prerogative of the chair. We're slipping into partisanship here.
Well,
and I'm not going to go there because we're not allowed to do that. What we're debating here is maps that were created. Do they fit the 7 criteria of Proposition 4? If we're going to go beyond that, I'm going to disallow it. Quite honestly, Representative, you've slid into the part that I wouldn't let either party slide into here, and I'm not going to allow it.
Okay.
So keep your questions valid to the Prop 4 criteria and those 7 criteria.
Mr. Chair, if I could respond to that, one of the Prop 4 criteria is whether the map unduly favors or disfavors any party. So I appreciate that we don't want a partisanly drawn map.
But you indicated a certain percentage of proportionality.
Yes.
In partisanship.
Yes.
I'm not going to allow that.
Well, the point, if I could,
I'm the chair. I'm not going to allow it, Representative Owens. You can have discussion around the 7 criteria without partisanship. Go ahead.
When you apply the partisan symmetry test, Dr. Trendy, you are looking at partisan data, right? You're just not reporting that to us in the legislature to separate us from the partisan decision.
That's correct. The computer generates the computer looks at the data and generates how many seats are above the statewide average and how many are below.
Would your partisan symmetry test allow a district that had a Democratic majority, theoretically?
I don't know. Probably because, because you still end up, if you call down the various sets. If you call down, take out the maps that don't meet the partisan symmetry standard from the ensembles, you still have a large number of maps left in both of them. So you could have a map that meets the partisan symmetry standard but still produces a Democratic leading district.
Mr. Chair, well, and just to clarify, Dr. Trendy, you drew the maps that were submitted by that have been submitted so far today.
So 3 of them are actually based on simulation maps made to be conform to the equal population requirements. 2 of them are based on the enacted map made to bring it into conformance with the other requirements. So I did draw them, but in a way, but not with a free hand.
I appreciate that. And then you have testified around the country in redistricting cases. Is that right?
I have.
Always for one party, right?
No, in Michigan, I was hired by a group of black legislators. I was working with the Democratic caucus to try to come up with remedial maps, so I don't think that's right. But generally speaking, if a Democrat were to ever ask me to testify and I thought I could give helpful testimony, I would. And there are times where I tell Republicans, I'm sorry, I can't say your map's not a gerrymander.
Mr. Chair, and I want to just clarify two or three more questions, Mr. Chair. Dr. Trendy, that Harvard set of 6,000 maps, those were all drawn without regard to a partisan consideration, right?
Yeah, that's why they're a good basis for some of these maps.
And you did not analyze whether your maps unduly advantage or disadvantage any party, right? That's not part of the symmetry test.
Well, but I compare them to the output of the ensembles and make sure they fall within the ranges, cutting off the extremes on either end of those ensemble maps. And again, some of them are based on, are drawn from that Harvard ensemble. So for the backbone of the map, there is zero partisan intent. But I do make sure that as things are coming along, as the populations are equaled out, nothing happens to push it beyond the ranges where you would say a map was drawn with partisan intent.
I appreciate that answer, but in answer to my question, it's no, you didn't analyze whether there's a partisan impact, undue partisan impact.
I don't think that's right.
Okay, you said yes.
I think my answer explains. For measuring partisan intent, we typically use these simulations to look at what the range of partisan free maps you would expect in a state. And so I make sure that these maps never, at the end, I run it, look to see if it falls within the range of what these ensembles would produce. That's the check on partisan intent. For unduly favoring, I use the partisan bias test.
Mr. Chair, let me just conclude with a request to the chair. Dr. Trendy has said that his test of partisan symmetry would allow a majority Democratic district. And the reason I'm talking about that, Mr. Chair, is that we're supposed to assess whether what we're doing unduly favors or disfavors any party. That's right out of Prop 4 I'm quoting. And it's my position, at least, that it is impossible for the partisan symmetry test to approve a map that has a Democratic majority in it. And it's baked in the cake if we adopt this test that there will never be and cannot be, and it's impossible to have a Democratic majority district. So I'd like to challenge the doctor to produce a map that shows, because he's produced these other 5 or 6, I'd like him to produce a map that shows a Democratic majority and applies his symmetry test, just to see if that's indeed possible, because I don't think it is.
Thank you for your comments. We're going to go back to Senator McKell. Is that you? No, Representative Brooks.
Yes. Got me off guard.
Representative Brooks.
Thank you, Mr. Chair, and thank you, Dr. Trendy, for all the information you've given us. I think it's definitely opened our eyes, provide some clarity to a lot of the issues. One of the first questions people asked me when I was assigned to this committee was, why don't you just use one of the independent redistricting committee maps? And I just want to make it clear, I believe what you said is the maps that were given didn't comply to Proposition 4. Is that correct? Did I understand that correctly?
Yeah, they failed both the partisan symmetry measure and the intent requirement. They would be flagged as partisan outliers by anyone who runs redistricting simulations to test for intent. At the same time, I think your instinct there is one of the reasons it was useful to draw upon as a source some of the maps drawn by Dr. Kenny's code from Harvard and some of the ones produced by my own simulations.
Thank you. Thank you, Mr. Chair. Thank you, Doctor.
Thank you. Dr. Trendy, we really appreciate your time. Was there any final comment that you would like to make before we let you go?
No, I'm just really honored that you all took the time to listen to my thoughts on this, and just happy to be a part of the process.
Thank you. The chair will look for a motion for let's see, what time have we got? 15-minute recess.
Motion for a 15-minute recess for bio breaks.
Any discussion? All in favor say aye.
Aye.
Any opposed? We stand in recess until 12 o'clock. Thank you.